Okay, welcome back. Ms. Tabaka, do you have any more witnesses?
Your Honor, I have
Yes.
a preliminary matter.
What?
I have a preliminary matter. I'm sorry for interrupting.
Okay, well, let me see if she has any witnesses and then.
Okay.
You have any more witnesses?
Yes, I do. I'm not sure if she's in the waiting room or not, but Nancy Sutherland.
Not yet.
Okay, no, we don't have her there. Miss Elaine, what's your preliminary matter?
Yes, Your Honor. I wanted to explore what happened toward the end of the hearing when Ms. Goldstein referenced testimony by Chris Tabaka and then denied that she referenced it and then denied that she listened to it. And her defense was that she was referencing her own testimony and said that Ms. Tabaka, in questioning Ms. Goldstein, referenced Chris's testimony that he walked Maddie to piano. And I don't believe that is true. I enlisted the help of Mary Beth Tabaka, who is also an attorney, to listen to that entire exchange. She listened to the entire questioning by Alexis of her mother from our hearing.
Okay, I'm not going to take any statements by someone else, Miss Elaine. I don't care, especially when they're related to somebody in these proceedings. So I guess whatever this other person might say, I'm not interested in hearing.
Okay, so I guess as an offer of proof, I would say that the YouTube recording of this proceeding does not, in fact, sustain what Ms. Goldstein testified under oath to this court, which is that she got the information from Alexis's questioning of her. She did not, in fact, get it from that. And we believe that she did, in fact, listen to the YouTube as it was occurring while Mr. Tabaka was testifying. And the first thing out of her mouth was when I asked her who made it clear to her, she said Chris made it clear. And then when she realized where that was going, she said, no, Alexis had used that in her questioning to me. And I believe that is a misrepresentation to this court because that does not exist.
Well, I guess I'll have to go back and listen to her,
Okay.
her questioning and that, just to make sure as to what it is and what weight we give to that testimony.
Okay. Thank you, Your Honor. I appreciate it.
Okay. Was it Sutherland you said?
Yes, Nancy.
I have nobody else in the waiting room right now.
Okay. She might be coming on around 1:40, quite possibly. Let's see. I can, well, I'm not sure about procedure, but I can bring up some of the exhibits pertaining to my motion where Chris had pulled the children out of school.
We can take some additional testimony from you at this time.
Okay.
You're still under oath.
Okay. I guess, I believe there was some questions that I was asking my mother that really needed to be heard from me, such as the child pickups. When I've been there, Chris has always been there. I know that was one.
Just testify. I don't need a narrative on it.
Okay. All right. So, in my motion that I had filed, regarding Chris violating the parenting order and my exhibits for that, the first exhibit I have is the 2015 order that we should probably have many copies of, but paragraph 4 of that order on the second page states that each parent will advise the other promptly of any illness, injury, emergency, or other significant event concerning the children, including school or health problems, if any, which the parent becomes aware. And on February 8th, my children were held out of school, to which I did not receive knowledge of that until approximately 3:15 p.m. in the afternoon which was after Maddie's school had concluded and about 25 minutes prior to the conclusion of when Daniel's school would have ended. I do not believe that that was promptly advising me of the alleged illnesses, nor did he bother to advise me that he had held the children out of school on that day. I do have in my exhibits, for what it's worth, the school attendance reports showing that the children were held out of school on that date. And then when I received my children at 7 p.m. that day that they were supposedly held out of school sick, I received my children with none of the issues that were in Chris's email. They were not sneezing, they were not coughing, and they exhibited no fever, perfectly well, no energy issues. And, you know, they had elaborated to me on the activities that they engaged in.
Objection to hearsay.
Right, I'm not going to obviously say what they told me. So based off of their being healthy, I had emailed Chris back, and that is also in my exhibits, you know, explaining that the children are healthy. They didn't say that they were, well, that the children were healthy, and that I didn't see a reason they should have been held out of school. And why was I advised so late in the day? And I informed Chris that because the children were healthy, I would be taking them to school on Friday, as my daughter requested that she wanted to go. So Friday, the 9th of February, I brought my children to school, dropped them off, and that was a Friday that would lead into Chris's weekend. It was a full day of school. However, when I received my children back on Sunday, February 11th at 6 p.m., I was made aware that the children were removed
Objection,
from school.
hearsay.
Okay, I have exhibits.
Well, hold on, let's address that, because
Mhm.
I did review all the pleadings, and Miss Elaine, your client has acknowledged that he took them out on the 8th. He acknowledged that he took them out on Friday, the 12th, so I don't know why we have to go in and litigate that at this point based upon his admissions.
Right. We were just saying it wasn't a violation of anything, Your Honor, but
I
yes.
understand that. I'm just
Okay,
saying,
yeah,
you
you know, you're right.
objected when she said she found out on on Sunday that they'd been removed on the Friday, the 9th.
Just from what the
I don't want
kids-
to argue about that because he's already admitted that.
Yeah, it was just a hearsay objection, Your Honor, but I get your point.
Okay. Go ahead, Mr. Baca.
Thank you. In my exhibits, I have the exhibit 10, which is a letter on 2/9/2024, a letter from Chris Tabaka to Marshall Middle School about removing Maddie from school at noon for a trip that she knows nothing about. So he took the time, obviously, to put together a letter to provide to the school to remove the children from school, but at no point did he communicate with me in any way, shape, or form that he was going to be removing the children from their regular school hours and taking them on a personal trip. I was never provided that information and did not find out about that at all until I received my children back on the 11th of February, at which time I went to the school to get their attendance records, see what was provided for their removal from school, speak to the school regarding the ongoing custody issues that we have, and letting them know that I am the sole custodial parent and that I would appreciate communication if something like this were to happen, saying it's not their responsibility to know everybody's custody order, but due to the intense nature of our case, that I would appreciate communication if things like this were to happen. And then with Daniel's, no formal letter was submitted. It was just him signing the children out of school at noon. Now, like under normal circumstances, in the way that we were able to operate civilly before everything kind of got crazy like this, I do believe this would have been a non-issue, and I don't intend to make issues out of things like this. The only reason that I'm bringing it up and that it's even coming before the court is that I tried to resolve these parenting time denials that he's claiming, many of which go against the ruling, saying, look, you just got 12 plus hours of parenting time that you took in a rather deceitful way, not advising me at all of removing the children from school. Can we please just settle this matter? Because I had already offered them an amount of time from their original bulk of hours, and then he got this time on his own. And really, I didn't see any reason why there couldn't have been a resolve. Like, I don't have any interest in having him held in contempt or in violation of anything. I sent multiple emails stating that I did not want to file a motion, that I wanted there to be just a resolve for the peace of everybody. Just to like set these little things aside so that we can move on. Because I feel like the longer this goes on, obviously it affects more than just us. It affects the children. But again, there's never any communication back about resolving these issues. It's he does things and then he gets away with it.
Objection, Your Honor, to it just seems like it's going a little off track at this point.
Well, I'll let it go. That's fine.
All right.
Thank you. I am not trying to say that he's a bad guy for doing this. I'm just trying to say that there's serious communication issues and really unnecessary motions that are taking place when there is clear opportunity to resolve issues with regard to parenting time. Like, I'm very aware that based off of your rulings from last May, that many of the hours in there are contradictory to your ruling. And, well, we could go after that matter. I'm not interested in like going after anything. I would like for this to be resolved. I would like for this to not have come before your court, Your Honor. I don't see why it could not have been resolved prior to today.
Anything else?
Well, I was wondering if if Nancy had.
She is at this point. I didn't know. Miss Elaine, do you want to cross-examine at this point, or you want to take the other witness?
Let's take the other witness, Your Honor.
Okay. Go ahead, Ms. Tabaka, when you're ready.
All right. Thank you, Nancy. Just a few questions. Did Maddie arrive at her 3 p.m. piano lessons accompanied by her father?
Most of the time since she started having piano lessons at 3 o'clock, her dad would bring her over from the middle school, which is about a block and a half away.
Okay.
They were
And,
usually waiting for me when I got here.
yeah. And would Chris often remain in the room for the duration of Maddie's piano lesson prior to the arrival of my mother?
There were some times that he was in the room. He'd stay for a few minutes sometimes. Sometimes he stayed longer than that.
Okay. And this happened on more than one date, correct?
I believe so.
Okay. And I guess those were my main questions. I just wanted to confirm that Chris had,
Okay,
fact-
we don't need your testimony, Ms. Tabaka.
okay.
Ms. Elaine, any questions for the witness?
Yes. Ms. Sutherland, when you said that Mr. Tabaka would sometimes stay a few minutes in the room or sometimes longer, on what dates did he do that?
I really have no recollection. You're talking about over 2 years ago. So
Okay, I have no further
I
questions.
really have no recollection.
Thank you.
Okay, okay. Any redirect, Ms. Tabaka?
Does Chris still arrive, or does Maddie still arrive accompanied by her father?
It's
Objection.
harder for me.
Objection outside the scope of my cross.
Ms. Tabaka, probably what you don't understand is when you redirect, you can only address what was brought up on the cross-examination. She didn't go into that.
Okay,
So as a result, you can't go back into it.
all right. I understand. Thank you.
Okay.
All right. and
Ms.
thank you.
Ms. Sutherland, thank you for your testimony. That's all we need. You're excused. Have a wonderful day.
Thank you.
Thank you.
Any other witnesses, Ms. Tabaka?
Do I have Leonard or Sharon?
Sharon is there, yes. Tabaka? Sharon?
Yes,
Okay.
yes.
Your Honor, I would object to the presentation of Sharon Tabaka just simply because there's no way she has any knowledge about any of the issues before this court today.
I have no idea until she testifies, I guess.
I'd ask for an offer of proof, I guess, for Ms. Tabaka.
Okay, well, I'm going to at least give an opportunity, so we'll bring her in and see what she says.
Okay, thank you.
Go ahead, Ms. Tabaka.
Thank you, Mr. Tabaka. So we're here on a number of different motions, but the motion that I filed is pertaining to frivolous civil action. And as you've been kept up to date on the matters of court, I just wanted to ask you a couple of questions. Because in all of my motions and answers to the court.
Objection, Your Honor, to the narrative that we're getting.
Yeah. This is your time to ask questions, not to give
Okay,
the narrative.
Sure. I'm sorry. Does Christopher Tabaka keep me in court to harass and abuse me?
Objection, Your Honor. Relevance.
How is that relevant, Ms. Tabaka?
Just from his witness perspective to the case and being a party of everything over the last 10 years.
Well, we're not here about everything that's happened in the last 10 years. And quite frankly, the court's not concerned about his perspective. It's a question of whether he can testify to facts in this particular matter. If he can't, I'm not interested in hearing.
Okay. Then maybe you could, because I'm not an attorney, let me know. For over a year, it has been stated that the sole purpose of what Chris Tabaka is trying to do is to cause injury and to cause hardship to me.
Okay, let me clarify for you, and so you have to edify you in this matter. We're talking about, again, whether there was a denial of parenting time on those times contained in Defendant's Exhibit A or the dates that you would put forth in your motion on February 8th and February 9th. Those are the issues today before the court.
Okay,
So if he can testify as to any of those issues, the court will take his testimony. If not, then it's not germane to what we have to decide.
all right. Well, then I'm not sure how to proceed. Because my intent was to get a firsthand account and a witness for the abuse that I have sustained by his son, to get the court an understanding of why this is happening.
Okay, well, that's not an issue for this hearing that we're here today on. So if in fact that's germane some other way, you have a right to bring that in, but it's not before the court today.
Okay.
Okay. Well, with that, Ms. Elaine, is there any problem with excusing the witness?
No, Your Honor.
Okay. Mr. Tabaka, you're free to go and you have a wonderful day.
I have a question.
Well, I'm sorry, we're not here to answer questions for you, and I'm sorry about that, but you were here to
So-
testify, and
So
it's
it's a closed
been
hearing.
clear that there is no testimony, so we don't need you to testify today.
I see. You don't want to hear anything unless what you want to hear. Thank you.
Well,
very
we
much.
only hear what's germane to the issue before the court. That's it.
I see. Very good.
Okay, thank you. Have a wonderful day. Any other witnesses, Ms. Tabaka?
No, sir, I don't believe so.
Okay. Ms. Elaine, do you want to continue with your, or go ahead with your cross-examination of Ms. Tabaka?
Yes, thank you.
Okay,
Let me just get situated here back into that set of notes.
and again, Ms. Tabaka, you're still under oath. We just,
Yes, sir.
we can get your witnesses in.
Yep.
All right, Ms. Tabaka, I'm going to show you what we have pre-marked as our Exhibit F. And all right, do you recognize that?
Ms. Elaine, just clarify, that's not what I have for your proposed Exhibit F.
Would it be the third page, Your Honor, by any
Yeah.
chance?
Yes.
Okay,
Okay, so you had, okay. I thought it was only the one page. So
I'm sorry, I should have said this one is 4 pages for the
4
record.
pages. Okay, thank you.
Ms. Tabaka, do you remember getting that memo from Stephen Hinckley at the Calhoun County Sheriff?
Yeah, I remember receiving it from a union representative.
Okay, and this relates to your time off from work and whether you're coming back in the particular job and so forth, correct?
I believe so. Without reading the whole thing, it pertained to my inability to work and the decisions between the department on retaining me,
Right.
not firing me and me not quitting, but
Okay,
putting me in a position of personal leave in good standing.
all right. And then this last sentence of the first paragraph says, while you did attempt to return to work for a very brief period, we understand from further discussions with you that you do not think you can continue to work in your current role due to your medical condition and other factors such as childcare, transportation, and court hearings. Is that an accurate representation?
I probably should have read it more clearly when I was signing it, but I was pretty emotional about it.
Okay,
It was not that you do not think you can continue to work. It was more geared by the supervisors and their expectations of the role, and not feeling that my circumstances could accommodate the position.
All right. But just to be clear, it was your claim of the medical condition and then issues with related to childcare, transportation, and court hearings. Correct.
It involved the ability to attend appointments regarding my health and the ongoing litigation hearings.
All right. And then you didn't have a memory before of what exactly had happened with your leave, but this letter says that Calhoun County was notified by the short-term disability carrier that your disability claim was not extended and your appeal for disability benefits was denied. Do you recall that now that you see that in writing? What had happened
Sure.
with that? All right.
Vaguely, yeah, sure.
All right. I would move for the admission of F.
Okay, Mr. Bach, any response to the offer of F?
No, that's fine, Your Honor.
Okay, court will admit defendant's exhibit F.
All right, Ms. Tabaka, with respect to your own show cause, so the one that you filed, just so that I'm clear about your testimony, you have no interest in the court holding Chris in contempt of court, correct?
Correct. I'm pretty sure I sent that in emails to you.
Okay. And the reason you filed it was because you didn't feel like Chris was making an effort to settle his parenting time complaint, his show cause against you.
Basically, even before he took the time of his own free will and without communication of the children out of school for personal time, the schedule you put together with the hours was so far from the rulings on May 12th that there was little there. And even at that point, I offered to settle. But
Okay,
but then when he began to just take parenting time on his own free will, which I believe I wrote this, is very counterproductive to the proceedings that we're dealing with. I still tried to communicate, hey, this is not right. You're asking for this, but you've got your client doing that, and you still don't want to come to a resolution.
So to be clear, when Chris had the kids out of school for the times that he did, you didn't miss any parenting time, right? You wouldn't have had the kids during those hours, correct?
I don't take my children out of school to take parenting time.
So the answer is no, you did not miss any parenting time.
No.
So contrary to when you have withheld the children during the work parenting time provision times, Chris has actually missed parenting time with his children, correct?
Not of the stuff that you've sent to me that I've reviewed, not according to the rulings that the judge put
Well, if
on
the
me.
judge rules in Chris's favor, then that would be a finding that in fact he missed parenting time, correct? And the judge will decide that. But we're not talking about him not having the kids and claiming that, like, you did not, your kids were in school, and so you weren't deprived any parenting time. Would you agree with that?
Correct, because neither one of us are supposed to be using school time as parenting time.
All right. And you agree that the Thursday that Chris had the kids out of school for being sick was his parenting time day, correct? Thursday is his day. They had spent the night Wednesday at his house, right?
Thursday would have been his day.
Mm-hmm.
However, there was no indication that the children were sick.
Okay, so let's take a look at the order from 2015. All right, so I'm showing you, I'll just show you the top here. Order for custody, support, and parenting time. Custody of the minor children. This lays out the joint legal custodian, well, provisions under the title joint legal custodian 1 through 8 and 1 through 9. Do you see anything in 1 through 9? And I can scroll down that says he can't keep the children out of school if he feels like it.
I read in number 4 that each parent will advise the other promptly, which is pretty clear, of any illness, injury, emergency, or other significant event concerning the children. And then goes on, including school or health problems, if any, which the parent becomes aware. So on February 8th, there was an illness apparently that was well known in the morning because they were held out of school all day that he did not promptly inform me of until the conclusion of school that day. And then where it says including school, I was never informed, not promptly or by any means whatsoever, of the removal of my children from school that day by Chris at all.
So
Yet he took the time to write a letter
okay,
to the school to take them out.
let's talk about each day separately. All right. So let's talk about Thursday, February 8th. Is your theory that they weren't sick and he held them out because he felt like it? Or is your theory that they were sick and he did not promptly notify you?
I don't know his reasoning for not promptly notifying me. However, I do believe, considering he had an out-of-state road trip planned with the children, that the nature of his removal of the children on Thursday, claiming that they had a fever, was to take advantage of the school's sick policy, which states that if the children have fevers, they cannot come to school for 24 hours. And that would have opened up a window for him to leave for his vacation, basically Friday morning, when he would have gotten the children back.
But you put them in school Friday.
I
right?
did, because the children were feeling well, and at no point did they have any temperatures, any sneezing, or any coughing like was declared in an email and asked to go to school.
So your theory is that he held them out of school Thursday, even though they weren't sick, so that he could take them Friday.
Yes.
Okay. So in that regard, is there anything in this order that prevents him from keeping them home from school just because he feels like doing so?
Each parent will advise the other promptly of any illness, injury, emergency, or other significant event concerning the children, including school.
Well, including
problems.
school or health problems.
Yes, school. So if
problems
you're
or
going to
health
take the
problems.
children out of school, I believe that this is fairly clear that you would promptly advise the other parent of such. Just
Well-
like you would promptly advise if they're so sick that they're not going to school, you would promptly advise the parent of such, which he didn't promptly advise.
Well, we'll get to that, but it doesn't say he has to notify you if he keeps them out of school. It says he'll notify you if there are any significant school or health problems. So if he's holding them out of school, that's not a problem, right? I mean, he's just a parent holding his kids out of school.
I would say that's a matter of opinion, and that the order does specifically say a significant event concerning the children, including school.
But a
So
significant,
if you are removing the children from school, that is something that should be shared with the other parent. And it was never shared.
when did you take your children to a wedding and take them out of school for a wedding?
I believe it was probably maybe October of 2022. The children were picked up 40 minutes early to attend a wedding.
All right. And did you notify Chris about that?
I don't recall. It was a couple of years ago.
But by the time of October 2022, the only communication you and Chris had was through Our Family Wizard, correct?
I believe so.
So if you notified him that you were taking the children out of school, which you claim is a significant problem, under this language, then we would find that in the Our Family Wizard if you did that, right?
I would imagine so.
All right. And when did you take them out of school to go to Ohio?
Miss Elaine,
Yes.
how is this relevant to the issues before the court?
Because she's claiming that there's a requirement to notify the other parent if you take the children out of school, and she's done it numerous times without notifying Mr. Tabaka, so.
And there's nothing in it, there's nothing in either of the motions that addresses that. So the matter is not before the court. I'm not going in and dredging up years of past events just as a kind of a get even, so.
Well, I'm not asking for relief on that, Your Honor. What I'm saying is, she can't have it both ways. She can't violate what she claims is an order, which we don't agree that it is, by the way, but she's saying he violated this order by taking the kids out of school, yet she's done it multiple times. So she has to pick her poison. Either that's not a violation and it was okay that both of them did it, or it was a violation and she's also has violated it.
If she violates the order, then you need to bring a motion to address that. I don't think it's relevant, so move on.
Okay, thank you, Your Honor. All right, so let's turn to your interpretation of promptly, Ms. Tabaka. So he did notify you that same day that the children were sick, correct?
Yeah, at the end of school.
But he did notify you that day that they were sick, right?
The word is promptly, and that word is in there specifically.
Yeah, I understand. And you've always promptly notified Mr. Tabaka that the kids were sick?
Yeah, if the kids were sick.
All right, and isn't it true you didn't even tell Mr. Tabaka when Daniel was really sick and ended up having COVID?
I have no idea what you're talking about.
Didn't you take Daniel to school, to your work, and have him lay on the floor with a blanket and pillow because he was so sick? And that's when he ended up having COVID?
I do remember years ago having my son with me. I can't remember the circumstances. It was quite a long time ago.
All right, but you did do that, and he was sick, and you didn't even notify Chris at all, correct?
What was that?
When he was so sick that you took him to work and he had to lay on the floor, and then he ended up having COVID. You never notified Chris how sick he was, correct?
I have no idea because what you're referring to is years ago.
Okay. I'm pointing you to what is marked our Exhibit O, which is a series of Our Family Wizard messages. And I want you to look at this message dated July 12th of 2021.
Your Honor?
Yeah.
May I just state that she is bringing up documents from 2021, and really what I'm bringing up specifically involves actions that are taking place during the pendency of proceedings regarding parenting time, and so are relevant to one another.
Okay, Miss Elaine, how is this relevant?
Your Honor, in order to find that Mr. Tabaka violated a court order and hold him in contempt of court, in order to find him in contempt, you have to find that he willfully violated a court order. And if the party's history is such that this sort of timing of notification was in their regular practice, then you would not be able to find that he willfully violated a court order, even if you have some definition of promptly, whatever the definition of promptly is. I think the party's intent shows what they have exercised or what was in their mind as promptly. And so their history bears on that question.
Well, the court looks at the orders and interprets the orders. I'm not going back to past history and saying, well, because somebody did it in this instance, that it's all right to do it in that instance. The court will take each incident of contempt separately and assess it at that particular time. So I don't know how something happening in 2021 is relevant.
Yeah, again, Your Honor, I think Ms. Tabaka keeps saying it's it's clear, and I chuckle not at her, but just because if everything was clear, we wouldn't have lawyers in courts, right? The words are
That's
not,
true.
the words are not clear. And so I think in order to determine whether he willfully violated an order, we have to figure out what the parties understood as promptly. And I mean, I guess, Your Honor, maybe it would be helpful if we cut to the chase. And if Your Honor is interested in exploring if Your Honor is thinking that it might not have been prompt for him to notify her the same day that the kids were ill and out of school, I guess we could start there. And maybe I'm wasting time that I don't need to be wasting.
Well, again, the issue of whether it's prompt or not is obviously something the court is going to have to decide.
Right.
And so it'll get into that particular definition and not necessarily be what the party had done in the past, because obviously what they did in the past may not have been prompt. I don't know.
I guess one further offer of proof on that would be that in the past practice, there was no complaint from Alexis when Chris notified her hours after the fact that he encountered sickness of the children. She didn't complain and say, you're not doing this in a prompt fashion. And I think really her testimony a few moments ago says it all, that there is nothing to this. She only brought it because he's show causing her. That's the reason she brought it. This would not be
whether her motivation, she has a right to bring it. If in fact, again, he is in contempt, then the court will make a determination based upon the facts. I would state when you got to the issue of prompt, the court did thinking, okay, what's prompt? The court looked up under Webster's dictionary, and prompt is defined as on time, punctual, done without delay. So that's the definition on Webster's.
Okay. So Alexis, he did notify you that the children were out sick, correct? The same day they were out sick. And I'm pointing you now to our exhibit N, our family wizard message 553. Is that the exchange?
That was the first notification that I got. It was after Maddie's school was released and 28 minutes prior to the release of Daniel's school.
I understand that. I understand that. I'm asking you if that's the Our Family Wizard that he notified you with.
That was the first notification I got that the children did not attend school that day.
Okay. And in response to that, you said, thank you for letting me know. You didn't say, why didn't you tell me earlier, correct?
Because other issues.
Ma'am, my question is, did you say to him, why didn't you tell me earlier?
Generally speaking, when it comes to my communication with Chris, I try to say the least amount possible because there's often a lot of negativity, and I try to avoid conflict.
So the answer is you did not say, why didn't you tell me earlier? You said instead, thank you for letting me know, right?
That is what I wrote.
And do you consider coughy, stuffy nose, and fever a significant illness?
I if those symptoms had truly existed, then I would be fully on board with, yes, of course, hold the children out of school, except for that is not the case with the situation.
What do you mean that's not the case, the situation?
Well, I'm aware that we cannot call the children to be witnesses of their own lives. However, testimony from my mother who saw the children and from myself is that the children were received with no coughing, no sneezing, and no fever, and their daily activities were shared with us.
Okay, so we're back to that question I asked you a few minutes ago. Your theory then really is they weren't ever sick in the first place.
Right.
That's your true belief, correct? They weren't sick.
I absolutely believe that, yes.
And then with regard to the next day, Friday, February 9th, the children went to school. They were in your care and they were fine, so you sent them in, yes?
Mm-hmm.
Yes, for the record. You
Yes.
must- Okay. And then Chris took them out around noon to go on a trip, correct?
Yes, I learned that on Sunday, following
Okay.
Sunday.
And there's nothing in the prior custody, the governing custody order, which I'm going to pull again. There's nothing in the governing custody order that says that he can't take the kids out of school to go on a vacation, correct?
There are things written in the order that anything regarding school is not unilateral, but also
Where
No.
is that? Hang on, where is that?
I guess technically it's number 5. The parties will consult together and not decide unilaterally concerning major decisions involving health, education, and welfare of the children.
Can you just point me to that, please?
Yes, it's number 5.
Number 5, okay. Consult and not decide unilaterally major decisions involving health education. Do you consider taking the kids out of school at noon on a Friday a major decision affecting the children's health, education, and welfare?
I definitely consider removing the children to be something that you would share with the other parent. If I don't know that my children are gone from the school and I have to go to the school for any reason to see my children or anything of that, and then I find out that they're not there and I was never notified and I have no idea where my children are, that puts me in a very uncomfortable place as a parent.
So that wasn't my question. My question to you is, do you believe that taking the kids out of school at noon on a Friday fits under 5, that this is a major decision involving their education that has to be made mutually? And we're not talking about notification, right? We're talking about joint decision-making under number 5.
I see the parties will consult together and not decide unilaterally. And education is one of those factors in there.
So I'm just trying to get the answer to my question. Do you assert that taking the kids out of school at noon on a Friday to go on a vacation is a major decision involving their education that should not have been decided unilaterally?
I think that considering the circumstances of the litigation that we are currently involved in, that yes, there's much more bearing on that than there would normally be if things were just normal. Yeah.
So these provisions fluctuate in their application depending on the relationship between the parties at issue.
Well, I do believe that is the purpose of the order generally, is that you have to rely back to this if you can't just agree and get along on your own. I believe that it's the order that you fall back on.
But you're saying that in this particular situation, this paragraph has more importance or more application than if.
I mean, I guess I could have added that, but I really wasn't adding that paragraph. Really, it was a simple, it's more simple than I think you're making it out to be. It's just a simple prompt advising to the other parent of what's going on. And Chris didn't do that and provided zero information to me of removing the children from school, which is there. It's right there in number 4. And again, my goal is not to be like, yes, I want to hold Chris in contempt. Oh, I'm just going to get him. I don't care about that. All I care about is let's look at apples for apples here and say, okay, you got 12 hours with the kids and I hope you had a really wonderful vacation. And I'm sure the kids had a good time. And why can't we just let these ridiculous motions go that really have very little bearing, and that actions like this are just counterproductive to the fight that you're trying to put up against me, saying that I'm denying you parenting time when you just take it when you want it.
If I haven't moved for the admission of N, I will do that now. Who did you confer with between the time you were notified that the kids were out of school and the time you did write Chris an Our Family Wizard message accusing him of violating the order? Who had you conferred with about that?
I probably had personal conversations with family.
All right. So was it your family who then suggested to you that you should try to do something about this and make an issue out of it, even though you hadn't really felt like you needed to do that at that point?
Miss Elaine, how is that relevant, just to who may have prompted her to do that?
I just think that it goes again to show the nature of what she is doing, Your Honor. She's acknowledged that she has no interest in having him held in contempt of court, that in normal situations, she wouldn't have brought this, and she's just doing it out of vindication. And
I don't think it's just vindication. She's saying she's doing it because he's pursued, a motion against her as well. So I think
right.
that's the impression I get. So I don't think it's relevant as to who she spoke to or what they might have told her.
Okay, thank you. All right, I have no further questions for
Okay.
Ms. Tabaka.
Thank you.
Mr. Baca, any additional testimony?
The only testimony really that I have to give is that maybe both parties here.
Okay, that's not testimony.
Okay. I'm
You'll have
sorry.
you'll have a chance to do final argument. You can bring up
Okay.
anything else.
That's fine. I don't believe then, sir, that I have.
Okay, thank you. Any additional witnesses, Ms. Tabaka?
No, sir.
Okay. Ms. Elaine, do you have any additional witnesses, rebuttal, et cetera?
Yes, I'll call Mr. Tabaka back for rebutting
Okay.
and for testifying as to, for the first time, as to the show cause, the second show cause.
Mr. Tabaka, you're still under oath.
Yes, sir.
All right, Mr. Tabaka, you heard the testimony of Mary Goldstein, correct?
Correct.
And you heard her testify, first of all, with regard to May 16th, that she was there waiting to pick up Maddie from school. Did you hear that?
Yes.
True or false that she was there waiting for Maddie on May 16th?
Absolutely false.
And how do you know that was absolutely false?
Because I was standing there at 2:30 when Maddie came out of school, and we stood there for a half hour waiting for somebody to show up, and nobody showed up. Mary Beth and I were together there.
Well, when I asked her how that could be, she said she was in the pickup line. Can you tell us if there was a pickup line that day at Maddie's school at 3:00?
There's a massive pickup line at Gordon Elementary because the kids are young. The middle school, on the other hand, is extremely different, and all the kids and all the cars are gone within about 7 minutes. I mean, just that school empties out fast. About 80% of the kids just walk home, and very few parents are actually picking their children up there.
And Madeline is at the middle school.
Correct.
So when she testified that at 3:00 there was still a big pickup line that she was in, it's your testimony that was false.
There was absolutely no pickup line as of about 10 minutes after school got out.
How many people were around you and Maddie and Mary Beth while you were sitting there waiting with Maddie for someone to pick her up?
It was pretty surreal. It was a ghost town. It was the three of us. Everybody else was gone. There weren't any kids. I mean, it was weird. at 3 o'clock.
And she talked about, I didn't really understand it, maybe you did, that you pulled the kids out of piano. She was trying to make a distinction between 2022 and 2023 and mentioned that you pulled the children out of piano. Have you ever pulled the children out of piano?
No, we've actually supplemented the kids going to piano. I think last summer we did alternating weeks with Alexis. We had kids in piano before that. Alexis unilaterally took over piano this last fall. So, and we've got lots of other things going on. So we have not been involved in piano since then, but we never pulled them out of piano.
Do you have any idea what she was talking about?
I don't.
Why do you walk Madeline to piano?
We joke around about all over in a van. I shouldn't go into stories. Safety. It's going right past the library. There's some really interesting people who hang out in the library parking lot. All the kids are there, a lot of kids there. It's not a super big deal, but I'm slightly helicopter, so I want to make sure she gets to piano safe.
All right. And those times that you're walking her to piano, is that something, if you had the parenting time based on the work parenting time provision, like you did for 7 years or so prior to 2021, would you be taking her to piano or would you choose to use your parenting time in some other way?
I'd probably be using my parenting time in a different way. What I have is very limited, and yeah.
Why is it that, well, first of all, do you contest Miss Goldstein's testimony that she has seen you at the end of Maddie's piano lesson almost every single time?
Absolutely. It's not true.
And how is it that we know that's not true?
Because I'm not there.
What do you-
Nancy said, I take Maddie over there, talk to her for a few minutes. Sometimes I go down and say hi to Nancy, and then leave. I come home, have about 15, 20 minutes, and then walk over to see Daniel at the elementary school.
And when Daniel is getting out of the elementary school, is Maddie still in the piano lesson?
Maddie's in piano until about 3:30, I believe, and Daniel gets out at 3:35, 3:38, 3:40, depending on the day. So, I mean, physically, there's almost no way to make it from piano to be over there as it is.
That's what I was going to ask you. If you were staying until the end of Maddie's piano lesson every single time, would you be able to then be at Gordon when Daniel gets out?
No way.
Were there times that Mary Goldstein claimed that she picked up Maddie from piano and you were there that you know to be false because Maddie was actually in a different place and not at piano?
Yes.
And what period of time was that?
Maddie had tennis last spring, a year ago, from mid-March to mid-May. And Mary testified that she saw me at school when she picked up Maddie, but Maddie wasn't there. Maddie took a bus from the middle school up to the high school, or she was at meets, either at the local high school or other area high schools. So she couldn't have seen me there because I wasn't there.
Miss, sorry, I'm blanking on her name, the aunt to Lily.
I don't remember her name either.
She testified, I'm sorry, I know it's in my notes, but trying to find that at this moment is challenging. She testified that there was one time in November of 2022 that she went to pick up the kids and you hung around for 10 minutes. Is that true to the best of your recollection? Not
even close. It was 30 seconds to 1 minute. Daniel didn't recognize her. I didn't know her. She came with another aunt. So I talked to them briefly about what they were doing, who they were, because I had no notice and had no idea what was going on. But we were not there for 10 minutes. It was 30 seconds to a minute.
Do you ever stay for 10 minutes when Alexa sends a proxy to come pick up the children?
Not with the kids, no. I mean, occasionally I'll stay and talk to a couple of the teachers, but I don't keep the kids in any way, shape, or form. I mean, it's her time. I recognize that. So as soon as she pulls up or we see her, the kids are off. Do you have any idea? Mary said that she likes you just fine. You get along great. And do you have any idea why she would lie like this? I think Mary holds me responsible for Alexis's decisions, unfortunately. So I don't think she likes me very much.
To the times in your spreadsheet where you're asking for an hour of parenting time to be granted to you, you went over that a little bit, that you explained that Maddie gets out of school early, and so really the time is an hour and a half that you missed, and Daniel gets out a little later, so it's really shorter, and so you averaged them. If the judge is inclined to not award you an hour of parenting time, how many times what were there that you averaged an hour when it could have been Maddie at 1.5 hours?
I'm gonna say roughly 10, plus or minus 1.
And
with a quick glance.
do you think it would feel equitable to the children if you got makeup time for just Maddie and not any makeup time for Daniel, because his were under an hour?
Daniel's a really sensitive soul. I think it'd be rough on him.
So instead of asking for 15 hours for Maddie and 7.5 for Daniel, you just averaged them out and having to the 10 hours, correct?
I did, yes.
Okay. And just to be clear, when we looked at the court order from May of 2023, the court had said from that time forward, he would not consider any hour or less in makeup time, correct?
Correct.
And the hours that you're requesting are all occurred prior to that date?
Correct.
All right. With respect to the show cause that Alexis filed against you, did you consider the children to have a significant illness?
Significant enough to keep them out of school, yes. I mean, I was on the fence in terms of the decision that morning. They were borderline in terms of both of them, like on the edge of whether or not to let them go to school or not. Quite frankly, the thing that pushed it over the edge was a message from the middle school principal the day before, which hopefully we've got a copy here somewhere.
I think you wrote that. You sent it to Alexis in one of our family wizards.
I did.
I can pull that up. All right. This is part of Exhibit N that's been admitted, so I'll show that real quick. So this is your message to Alexis on February 9th. Are you referencing that part right here?
I'm referencing what Tara Agnetuk, who's the principal of the middle school, sent out to all parents on February 7th at 9:24 in the morning.
All right. And just so we know what that says, can you read that?
Sure. Illness at MMS. There are some truly nasty illnesses going around MMS this week, Marshall Middle School. If your child is experiencing a cough, sore throat, fever, or any other flu-like symptoms, all caps, please, please, please keep them home so we can stop the spread. From Tara Agnetuk, principal of the middle school.
All right. So did you consider I think what you just said is they were borderline. So they weren't massively sick, but because of this, you said, well, I'm going to err on the side of caution and keep them out.
Yeah, Maddie had a consistent cough. She wasn't feeling right. Her forehead was damp. She wasn't right. Daniel was complaining of a sore throat. And between that and the message, I decided to basically put them to bed.
All right. And in fact, did they recuperate that day?
They both slept all morning long, about 3 hours. Well, I can't remember which one was. One slept about 3, one slept about 4. And when they woke up, they were feeling much better.
All right. And did they then engage in some activities?
Yeah, I had them do their homework and Madeline communicate with the middle school in the afternoon until they were done. Maddie really wanted to go to her art class that afternoon. I had her wear a mask. She looked fine. She felt fine. So I let her go to her art class with a mask. Then Daniel wanted to play tennis, so we did that. The sleep just did worlds of good for them.
All right. And you did end up notifying Alexis that they had been sick and kept home from school that day, correct?
Correct.
And was your notification the course of your normal practice of how you handle that?
Well, I wasn't expecting 2 sick kids that day, so I had to re-alter my entire schedule, take care of the kids, their first priority. So yeah, I got around to sending a message to Alexis at 3 that afternoon.
Okay. Was that in the normal course of?
Yep, that's how things always had been done.
And then the next day you took them out of school for a holiday that you took a short weekend trip, correct?
Correct. Took them out We had popcorn over at Gordon, so my wife and I did popcorn. Daniel helped out. Then I took them out of school at noon for a surprise trip down to Kentucky. During the car trip, they worked on their homework until school was over. That's how things work in my house. So,
All right. And is there anything that you're aware of in your custody order that prevented you from taking the children out of school?
no, not at all. It was standard practice.
Is there anything in your custody order that you're aware of that prevented you, that required you to notify Alexis that you took him out for a couple hours on Friday?
No.
All right, I have no further questions, Your Honor.
Okay. Mr. Baca, do you have any questions of defendant?
Yes. Let's see. So you stated, Chris, that it's pretty common practice just to send an email whenever regarding the children's illness, but that's not true, is it?
Did you rephrase that, Alexis? I'm still understand.
Hey, sir, we couldn't hear you. You have to speak up, maybe.
To
Mr.
my
DeBaca, Mr. DeBaca, restate your answer. We couldn't hear it.
Oh, sorry. I didn't understand your question. I was asking her to please repeat it.
Okay, repeat your question then.
Chris stated to the court that it is not uncommon that he would inform at any given time regarding the illness of the children, and that's not the case. Historically, if the children have ever been sick, we've always...
Section to the
Is
testimony.
this a question, Mr. Baca?
Well, maybe it started as a question, but...
Yeah, I think it got off track. So
Yeah.
ask the question.
I guess I'm not sure that I have any other questions. I feel like I have addressed the main points of
Okay.
what I consider to be the violation of this motion and its relevance to the one that they have filed against me.
Okay, thank you.
Mhm.
Ms. Elaine, any additional witnesses?
No, Your Honor.
Okay. I guess I'll ask, Ms. Tabaka, do you rest your case?
What does that mean, Your Honor?
Means you're not going to have any more witnesses or any more examination or testimony?
Correct. I believe I've provided everything that I have. Yes, sir.
Okay. And Ms. Elaine, do you rest as well?
I do.
Okay. That concludes the proofs in this matter. Ms. Elaine, do you wish to make it open or a closing argument?
Yes, I do, Your Honor.
Okay, go ahead.
Your Honor, with respect to the show cause regarding the work parenting time provision, this is essentially just installment number 2 of what we've already done. And the times and dates that were listed on our spreadsheet were confirmed by Ms. Tabaka as times that she worked and did not allow Chris to have the children. There is no opportunity for her under the original order or under any interpretive work that this court did in May of 2023 for her to deprive the father of the children of the parenting time after school because she sends her mother or another proxy to pick up the children, or because they have activities that she has enrolled them in. That's just not the way the order is written, and it's not the way the court interpreted it last time we were here. Those times and dates are owed to him because she did not comply with the order and allow him to have that after school time with the children. Mr. Tabaka notified her many, many times through our family wizard that he wanted to exercise the times that she was not working. She vacillated between not answering him or accusing him of harassing her by asking for that time. And that's what he gets for trying to just exercise the time that he was given under the under the court's order. He is accused of harassment and trying to exercise that. She acknowledged last time and she acknowledged this time when she said everything had blown up back in 2021. She made a deliberate decision to deprive him of that time by pretending she was not working or not telling him that she was working and making us go seek that information through subpoenas and records in order to prove these violations. For that, she should be held in contempt. She has to learn that this is not acceptable. And while she doesn't like the provision as it stands, she has to try to get it changed. She can't just stop exercising it and decide that she is not going to honor it. And maybe one day that provision will be eliminated from their order, but that day is not today. And so the times that Mr. Tabaka listed here, totaling the, I believe it's 53 or 51 hours total, are the times that this court should award makeup time. Similarly to last time, the court should award his attorney fees and costs by allowing us to submit a bill of costs within 14 days and Ms. Tabaka giving her the opportunity to object to that if she so feels fit. With respect to the show cause that Ms. Tabaka filed against Chris, I find it notable, and I do hope that the court does as well, the fact that she said that she wouldn't have brought it. She has no interest in having him found in contempt of court, which I think really just obviates the whole proceeding today. She has no interest in it. And that she only brought it because he was not willing to resolve his show cause on her terms. And they are apples and oranges because he was literally deprived of time with his children, time he should have had. And she was not deprived of anything. He held the kids out of school because they were sick one day, and he took them out for 3 hours to go on vacation with them another day. She was not deprived of a single thing. Both of those were his parenting time days. And to say that having the sniffles and a cough from which they recovered pretty quickly after some extra sleep is a significant illness that needed to be conveyed to her, just on that basis alone is incorrect legally. It's not a significant illness. And I would caution the court to not say that's a significant illness, because I think that opens the floodgates of litigation, and this court will have hundreds and hundreds of parents complaining that they weren't notified that a child had some sniffles or a cough. I think that's a really dangerous, slippery slope, not to use a tired old adage. But promptly as well, he told her that day that the kids were sick and that he had held them out of school. I mean, it's the same day. I really just don't think that violates the order in the joint legal custody context. And I would note too, Your Honor, that in that order on page 2, the paragraphs that we were looking at come under joint legal custody. This court well knows that joint legal custody has to do with significant decisions, major decisions that have a significant effect on children's lives. And when we typically litigate cases where a parent is not telling another parent something, that involves really significant issues, significant illnesses, hospitalizations, urgent care where somebody broke an arm and a parent did not notify the other parent. That's the type of thing this is meant to encompass. This is not, these are day-to-day decisions. What Mr. Tabaka made, these were day-to-day decisions that do not fall within the purview of a legal custody situation. And so by that very nature alone, he had no obligations under this order to notify her that they were mildly ill. And he had no obligation to notify her that he took them out of school to go on vacation. It's just, he didn't violate any order. So we would ask the court to not hold him in contempt of court on that basis. And because Ms. Tabaka admitted that she's only bringing it really out of revenge for him bringing one against her on a completely different issue. Thank you.
Thank you. Ms. Tabaka, closing argument.
Sure, Your Honor. First of all, I really tire of hearing that I do things out of revenge, because I in no way seek revenge at all. Just peace for me and my kids. And Attorney Elaine just spent a lot of time again on provision for regarding, and she kept referring to it as serious illness, but it doesn't say serious illness. It says any illness, promptly of any illness. And it would have been simple enough to send any kind of courtesy at the time that they chose to hold the children out of school, to inform me of that. And then, of course, the day after that was a completely deliberate withholding of the information of the children being kept out of school. I mean, he claimed a fevers on the 8th, but then just admitted to Your Honor they played tennis, Maddie went to an art class, and then they went on a road trip to Kentucky. And I'm really neither here nor there with the details. I'm just looking at this part of the order that was clearly violated. And she keeps trying to say that I'm bringing this up out of revenge for him filing that against me. That's not the case. I don't particularly like to be put into positions where I have to defend myself against a person that's lying about me. But I think that in this particular matter, what he is trying to convince the court versus his own actions are so incredibly contradictory that they should absolutely be considered. I think that it should also be, I don't see why he shouldn't be also like held in contempt for filing with the court to request hours that Your Honor specifically said on May 12th don't count, hour periods of time, and then in the middle of proceedings today try to change what those hours are and say, well, 1 hour is really 1.5 hours. It's like information has changed over the course of this hearing to try and make the defendant look like he's in a better situation. But the reality is the short periods of time, part of the order from May 12th, that was very clear. And the days involving my mother's help all pre-existed that court hearing on May 12th. For May 12th, when you said that my mother couldn't do that anymore if Chris wanted to be the person to do that, I have never violated that. And so those were the considerations that I went through point by point over everything based off of your analysis that you gave us on May 12th, 2023, and added up the hours and made an offer to Chris. And with no counter offer or no desire to resolve anything. And then again, he uses taking the kids out of school to get 12 hours of parenting time, which is very contradictory to the case that he's brought before this court claiming he's denied parenting time. And I've said this already several times today, where I just tried to resolve these issues, to keep these issues from even being brought up in court, because combined, it's a very petty thing. He gets very reasonable time with the children, and I don't deny him all sorts of extra time with the children, which he'll never admit to the court. But I think Your Honor, looking at both cases and both situations, that there are times in their order that I did admit to and I did offer back in August to them. And then again, when he got the 12 hours taking the children out of school, I had then again tried to initiate resolve so that we didn't have to bring this to court. And there's just never any, there's never any feedback to resolve things. It's like he wants to bring this to court. And I don't want to bring this stuff to court. I do not enjoy court at all. And I just wanted to state for the record too, because Attorney Elaine brought this up a couple of times. She claims, Your Honor, in this deposition that she took of me in August, I believe, before she ever even gave me this list of dates, she was, and I'm not an attorney and I don't know the process, but she was.
Your Honor, I would object to anything that hasn't been testified to in the record today.
You mentioned this in your statements.
Well, she mentioned it in passing. She didn't introduce anything on the deposition, so the court isn't going to be considering that, so you can move on.
Okay, that's fine, Your Honor. Anyway, there's a great many things at play that I learned today that cannot be brought before the court that would be helpful to the understanding of these situations that will have to be addressed at another time. But as far as the matters at hand, I have also suffered massive financial damage when I still had counsel of my own.
Your Honor, again, this is off topic.
It's closing argument. Go ahead.
Thank you. Sorry to throw me off. It's my wishes, and I guess that what I think the best possible thing, what I would pray that the court would do regarding these matters combined is to make the issue just flush and also potentially impose maybe a temporary emergency change to the order, allowing for 50-50 parenting time with standard time and none of that extra information from when the children were in preschool, to help prevent misuse of data that is no longer relevant, so that we can focus on getting through the custody hearings with the least harm to both parties. I mean, that's what I would pray that the court would do for our family.
Is that all you have, Ms. Tabaka?
Yes, sir.
Well, I'll say as it relates to that issue is not before the court. So if you want to bring the issue before the court on a change in parenting time to the 50-50 or change in custody, however you want to clarify or categorize it, you have a right to do that or do it through stipulation with the defendant, but it's not before the court today. So, Ms. Elaine, anything else?
Just a couple things, Your Honor. I just want to show the language, because I do think this is an important point when this court is deciding this interpretation. So each parent, number 4 in the parties' custody order, each parent will advise the other promptly of any illness, injury, emergency, or other significant event. Significant event is a modifying clause, and that relates back to illness, injury, and emergency. So any other significant event, meaning that the illness has to be significant, the injury has to be significant, or the emergency has to be significant. And again, I just want to emphasize that the 1-hour restriction, as clearly stated in the May 12th ruling, was future forward. And so Ms. Tabaka complains that Chris is asking for periods of an hour. We've explained why, but even so, there was no restriction on him doing that prior to the May date. Thank you.
Okay, thank you. Well, that concludes the matter here, except for the ruling. What I'd like to do is check, obviously I have a lot of information to look over, a lot of dates, go back over the orders as well. So I'm gonna need some time to prepare that. I want to know if the parties are all available next Wednesday afternoon at 2:00. If not, then maybe next Thursday, and I have Thursday open, so we could do it in the morning at 8:30 on Thursday.
I can do 2:00 on Wednesday, Your Honor.
Okay, Ms. Tabaka, can you do 2:00 on Wednesday, the 17th?
Yes, sir.
Okay, good. Then what we'll do is we'll reset this and adjourn until April 17 at 2:00 p.m. And at that time, the court will give you a ruling.
Thank you, Your
Thank
Honor.
you. You're free to go. Have a good day.
Can you hear me?
Yes.
Oh, we're under an active tornado warning right now. We just had the sirens go off for like 10 minutes. So if I have to run, you'll know
Okay.
why.
That's fine. If you have to go, then just run and we'll know what's happening.
Okay. So, fair warning.
That's scary.
Yeah, I've never heard the sirens go off as long as they just did.
Okay, can you hear us now, Mr. Tabaka?
Yes,
Okay,
Sorry.
1 moment.
Good afternoon to everyone.
Good afternoon.
This is the time and place set for the court's ruling from the hearing on April 9, 2024. Court will note that both parties filed motions to show cause for violation of the court orders of 11/3/2015 and 9/25/2023. The court has considered all of the testimony evidence and given the appropriate weight to that. In these cases, credibility is always a consideration. Oftentimes, a party will allege that the other party or one of their witnesses is not truthful or has lied. The court has found, however, that inconsistencies in testimony does not mean that an individual has lied. Conflicting testimony can occur as a result of the witness's background, perception, bias, understanding, misunderstanding, or mistake. When inconsistencies occur, the court will attempt to determine if the inconsistencies can be reconciled by other testimony or evidence. There was some inconsistency in this matter, but not to the extent that the court would normally see. In that regard, the court will note that Ms. Goldstein, the plaintiff's mother, did testify in this matter. And when she was asked about walking, when Madeline was walked from school to her piano lessons, she stated in answer, it was made clear that Chris walks Madeline to piano lessons. Miss Elaine asked, how was it made clear? And I'm saying this because I did review I reviewed the testimony in this matter. Miss Elaine asked, how was it made clear? She said, it was brought up earlier in his testimony. So Miss Elaine then asked, so you listened to his testimony? She said, no, plaintiff said it when she asked me a question. I reviewed all of the testimony of the examination of Ms. Goldstein by the plaintiff, and the only place that was referenced to any statements the defendant made was when she was questioned, was defendant accurate when he was claiming he was denied time? And I don't, obviously in this case, I don't want to ascribe any violations by Ms. Goldstein of the sequestration order, but I know that she's been intimately involved in this case, so she could have had another explanation for how she got this information. But taking her at her word when she said it was brought up earlier in his testimony does make the matter suspect. And as a result, to eliminate any possibility that the sequestration order was violated and that Ms. Goldstein's testimony impact on the case, the court is going to strike her testimony. I would note in doing so that her testimony was of nominal value to the issues before the court. As a result, to eliminate
the chairman of the full committee.
we're getting feedback, so. At issue in this case, and the court will note, is the order for custody support, parenting time, and preschool daycare dated November 13, 2015, which provides that plaintiff would have physical custody The parties would share joint legal custody and defendant would have various parenting time. At issue in this order is paragraph 4 contained in the joint legal custody paragraph, which provides, and I quote, "It is further ordered and adjudged that as a joint legal custodian, each parent will advise the other promptly of any illness, injury, emergency, or other significant event concerning the children," and then parentheses, "including school or health problems, if any," and brackets, "which the parent becomes aware," end quote. Plaintiff complained that defendant held the children out of school on February 8, 2024 because they had fevers, coughs, stuffy nose, and no energy. Defendant states that he withheld the children from school in response to a notice from the school principal advising parents to hold kids out if they experienced any flu-like symptoms. Plaintiff testified that she received defendant's Exhibit N, which was the Our Family Wizard message on 2/8/2024 at 3:12 p.m. stating that defendant had kept the children out of school the entire day due to coughing, stuffy nose, fever. He testified that the children were bored. The Our Family Wizard message, as did defendant's testimony, confirms that the children slept most of the morning and, quote, "seemed better this afternoon," end quote. Defendant testified that the children felt much better in the afternoon, and Madeline went to an art class and Daniel went to tennis. Plaintiff testified that when the children came back to her at 7 p.m., that the children exhibited no flu-like symptoms. The court finds no fault with the defendant keeping the children out of school. This is a routine practice exercised by parents, probably each and every day for children. Each time sometimes these decisions are borne out, sometimes they are not. Defendant then removed the children from school on February 9, 2024 at noon for a surprise trip to Kentucky. Defendant never notified plaintiff of removing the children from school on 2/9/2024 at noon. Plaintiff testified she first found out about the children being removed from school and the trip on Sunday when the children returned to her. Again, the court finds no fault with Mr. Tabaka removing the children from school on a limited basis to take them on a vacation. This happens oftentimes by parents. The issue, however, is whether the defendant violated the November 3rd, 2015 order by not advising the other parent promptly of any illness, injury, emergency, or other significant event concerning the children, if any, which the parent becomes aware. I should preface my remarks by noting that this case has been extremely contentious and perhaps one of the most litigious cases that this court has had based on the voluminous pleadings filed and the hearings that have been held. Defense counsel argues that defendant's notice at 3:12 p.m. on 2/8/2024 was promptly given. Webster's dictionary defines prompt as on time, punctual, or done without delay. When the notice given on 3:12 p.m., approximately 7 hours after the children were taken out of school, was done without delay. The court believes that notice approximately 7 hours after an event, especially given the history of this case, was not promptly given. Counsel argues that paragraph 4 applies only to significant event and therefore it is not applicable. Paragraph 4, however, is a disjunctive sentence and each event stands alone. This sentence means that a parent must advise the other parent promptly of any illness, injury, emergency, or other significant event concerning the children in school, and health problems, if any. Other significant event does not qualify as any other circumstances listed in paragraph 4. The court finds that defendant, in noting that he did not notify her at all on the having taken him out on 2/9/2024, The court finds that defendant did violate the order of 11/3/2015 and is in contempt of court. Defendant filed a motion to hold plaintiff in contempt of court for failing to provide parenting time as delineated under the order of 11/3/2015. The court is not going to reiterate the basis for the motion as it was previously litigated and concluded with plaintiff being held in contempt of court by order of 9/25/2023. The earlier action was tried on 3/7/23, 3/28/23, and 5/12/23, involving other dates the parenting time was denied. The court does not. Two entries are dated 5/16/2023 and 5/19/2023, which post-date the last hearing on 5/12/2023. There is in the law a doctrine referred to as res judicata. The doctrine provides that a party may not raise issues that were heard in a prior action or those matters which could have been heard. But for this doctrine, the parties would be able to continually litigate every issue they desired over and over, or bring up every minute issue time and time again. The court will hold that the doctrine of res judicata bars all action for all parenting time violations prior to the date of the hearing on May 12th, 2023, as provided in the last evidentiary hearing. Therefore, we are left with two violations from 5/16/23 and 5/19/23, which were violations of parenting time for 1 hour each. The court, as a result, will permit the defendant 2 hours of make-up parenting time for these two missed parenting time. The court previously ruled that this provision does not apply to periods of 1 hour or less before school. And to address that point, Ms. Elaine had contacted our office concerning the order entered on September 25, 2023, stating that she believed the wrong order, that Mr. Schaefer's order had been entered. I'm looking to the order that we have in the file, Ms. Elaine, and it is your order, which states under paragraph 2 that you had questioned the provision does not apply to periods of 1 hour or less before school.
That's
As a
weird.
result, I don't know if Mr. Schaefer's order somehow got entered as well, but I note that the order that we have was your order and not Mr. Schaefer's order.
Okay, thank you for that clarification. That's good news. The one I was sent was the other one, so.
Okay, I don't know how that happened,
Okay,
but the one that's in the court file that we have was your order.
perfect, thank you.
In this matter, the reason the court had excluded the 1 hour before school was because of the transportation, and that, in fact, the transportation of the children would take would be a little less than an hour. And so the court felt that it was not appropriate to, in fact, utilize those times of an hour because the children would simply be in transportation to and from the plaintiff's home. The court, as a result, is going to expand, if you would, that 1 hour time frame to the time after school as well. The court's ordering of the make-up parenting time of 2 hours will be subject to the same conditions as set forth in the 9/25/2023 order. The order from the present action heard on 4/9/2024 will apply to all contempt actions by either party occurring before 4/9/2024. So the court will not entertain any other motions for contempt prior to that hearing. There was a request for attorney fees. The court will note that the plaintiff prevailed on her motion. Defendant prevailed nominally on his motion. Plaintiff did incur attorney fees prior to her attorney withdrawing on February 22nd, 2024, and defendant incurred attorney fees as well. The court will offset these attorney fees and not award attorney fees to either party in this action. Ms. Elaine, I will ask that you would prepare an order as to the 2 hours of makeup parenting time and denying the attorney fees under MCR 2.602 parens B parens 3. And Ms. Tabaka, you can prepare an order which would hold defendant in contempt and expanding the 1 hour to the after school as well, and submit it under the 7-day notice. Court would note, if either of the parties desire their exhibits returned, they can pick those up within 10 days of today's date, and if not picked up within that time, they will be disposed of. With that, I'll ask Ms. Tabaka, is there anything else that you believe the court has not addressed or needs to address before we conclude?
No, sir, I think that was very thorough. Thank
Okay.
you.
Ms. Elaine, is there anything you believe I need to address or have not addressed before we conclude?
Your Honor, if you could just clarify the way that you assigned the order drafting, and then if I might suggest that I prepare one order and send a draft of that to Ms. Tabaka to agree to, instead of both of us submitting something under 7-day with the possibility of having objections.
That would be fine. I didn't want you to be required to, in fact, prepare Ms. Tabaka's order because you don't represent her, and I didn't want her to have to prepare yours. But my
That's
intent
fine.
was originally to have one order prepared. It would be much simpler, more direct. And to go over that again, is the court would order that there would be an order for 2 hours of makeup parenting time under the same conditions as the September 2023 order, meaning they can't be held on the holidays and things of that nature, and that it would hold the defendant in contempt of court, expand the 1 hour time frame contained in paragraph 2 on the second page of that order, where it says, and I quote, "This provision does not apply to periods of 1 hour or less before school," and I would expand that to after school as well. And I think that addresses all of those points.
Your Honor, I do have a question about the 1 hour time, because if you recall from the hearing, that was an average because the children get out of school at different times. So
I understand.
Right, but I'm just, if you're going to impose the 1 hour limit for after school, how will that work when Madeline's time is, if it's an hour and a half? Should he just focus on that hour and a half and then not the lesser amount of time for Daniel?
You mean if
Because that's
it's
what
in fact denied?
I'm sorry, go ahead. I
You
didn't
mean
hear
if
you.
in fact it's denied in the
Right.
future?
Right,
Well, what I would do is I would not, because I'm not going to take into consideration the 1 hour. So obviously you'd be talking about a half an hour time if in fact there's a denial in the future. And the court would consider that.
all right, so we might just have instances where there's a violation as to one child, but not both, is
You
what I'm
might,
saying.
might have that. I don't
Okay.
know.
All right.
Okay? With that, the court will close the record. You're free to go. Have a good day.
Thank you.
Thank you, Your Honor.
Thanks.